can nullify those elections. So again, for the purpose of our argument this morning, the tribunal, let us give the tribunal the power to say it had the jurisdiction, the powers, to nullify the election by saying, look, something went wrong. But the next question, which is now very, very crucial, and where I felt, and I believe, that the tribunal committed a grave error, which I also believe will be rectified by the Court of Appeal in this country, which is the next court in the ladder of hierarchy, is what is the order? What order will the tribunal make? That takes us to section 140, subsection 2. And it says, where a tribunal believes that the election of a person due to qualification matter, that is, the person elected into office for this purpose, Darius, was not qualified to be elected into that office of the governorship of Taraba State, or for massive irregularities, or for non-compliance with the Electoral Act, or for any other reason whatsoever, where a tribunal feels that that person, Darius, did not qualify to contest the governorship in the first instance, ab initio, that it shall not, watch the words of the Electoral Act, section 140 subsection, it shall not declare the person with the second highest number of votes to be returned to the post, to the position, but shall order a fresh election. Shall order a fresh election. In other words, the tribunal in Taraba, although it sat in Abuja, I learned for security reasons, having found out that Gulak was not qualified to have contested the elections ab initio, all he should have done is to say, hello, you were not qualified. I hereby order a fresh election between you and Aisha to Alhassan.
All right, Chief.
But it went ahead to nullify the election, and say that a certificate of return should be given to Aisha to be sworn in as governor. My brother, I want to now point out the difference. The difference is in section 140, subsection 3. What does it say? That section is the only section that permits the certificate to be given to the person who has the second highest number of votes. And it says that if the tribunal finds out that the person who won the election, let's say for purpose of argument, Darius this time, did not have majority of the votes, maybe they did pluses and minuses, suppression and addition. In local government A, you did not have this. In local government B, you had this. After deducting, they discovered that he did not have preponderance of votes, the majority of votes. Then he said, in such a case, you will now declare the person, the next person, who has obeyed the Electoral Act and who has the next highest number of votes to be the governor of that state.
Does that case apply in this case, in this circumstance?
Sorry?
Does this case apply now, section 140, subsection 3 you mentioned? Does it apply in this case?
No, it doesn't apply to this case. It's section 140, subsection 2
that applies. That's what you say applies.
Because the elections were voided on the ground of non-qualification by Darius. And the non-qualification arose, according to the tribunal, from the fact that PDP did not hold proper primaries from which Darius emerged. And as since there was no primaries, it means PDP did not have a candidate for that election at all.
Okay.
Even in other words, the tribunal were right in all its assessment, all he should have done is to say, hello, gentlemen and lady, we are going to, I hereby order fresh election for you people to go back to the people to see their mandate. Not coming under section 140, subsection 3, which is when it found out that Darius did not have majority of the votes. In fact, the tribunal even dismissed the issue of card reader. They dismissed that aspect of the card reader that, look, the card reader brought in some votes and all that. They say, look, that is rubbish. We are not concerned with that. But that this man was not qualified in the first instance to have even contested this election because he did not emerge from a proper primary in accordance with Section 87, subsection 1. That is all the basis. So the tribunal, with all respect, was very,
what do you say? What do you say to those who, although haven't still seen all the relevant sections of the laws that you cited, say, well, the matter is not entirely predicated on his qualification or otherwise, and that it goes beyond the qualification of the PDP candidates to the fact that they didn't even present any candidates, and as such, they're deemed not to have participated in that election. So if you didn't participate in an election, how do you...
That's what the tribunal said. That's the point I'm making. I said, for the purpose of argument, let us say the tribunal was right. I didn't want to stretch that because I'm not the tribunal who saw the evidence before them. INEC was said to have testified that they did not witness any primaries. Don't forget, I've already quoted Section 85, subsection 2, which does not really make it mandatory, as far as I'm concerned, for INEC to attend to observe primaries, because it's an internal affair of a political party. And it says INEC may attend. May. That's what they use.
So are you suggesting then that relying on INEC's testimony in the court, by reason of the fact that it's an internal affair of the party, as you said, does that reduce the validity, or does it invalidate the validity of the testimony that INEC were to give in this case?
No, I've said INEC has done its job by giving its evidence that, look, we did not monitor, we did not observe any primaries that produced the governor.
Which the tribunal also relied on.
Just a moment. I thought you asked me a question. Can I answer it?
By all means.
Yes, I'll say. Go ahead.
No, go ahead, Chief. I was saying by all means you could answer it.
Okay, fine. Thank you. Thank you for permitting me. I am saying that I'm not quarreling with the tribunal for taking the evidence of INEC and believing it that Darius did not emerge from proper primaries of PDP. That is another matter which their lawyers, I'm not a lawyer in any of the matter, which their lawyers can argue and deal with. I am saying, let us agree with the tribunal that Darius did not even emerge from a proper primaries under Section 87, subsection 1 of the Electoral Act. I am saying, what should be the order? What is the relief that the tribunal can grant? What order can it make? Can it make an order that Aisha should be given the certificate of return as it has done, and that Darius will be removed from office? Of course, don't forget that under Section 143, subsections 1 and 2, Darius has 21 days within which to appeal. And within those 21 days, he remains the governor. And throughout the pendency of the appeal, he remains the governor until the Court of Appeal decides. But so I am saying, let us agree with the tribunal in all its assessment that all this were right. What order ought it to make? The order is not saying, take the certificate of return from Darius and give it to Aisha and swear in Aisha as governor of Taraba State. The order the tribunal is permitted to make under Section 140, subsection 2, is to order a fresh election entirely between those two candidates that are toggling, that are quarreling. Because it is only under subsection 3 of Section 140 that you can say, give that certificate to Alhassan. And the situation is, if the tribunal had found that Darius did not have majority of the votes, the tribunal did not find out that Darius did not have majority of the votes. In fact, he found out that he did have majority of the votes.